The Commission on Security and Cooperation in Europe will come to order, and I want to welcome our very distinguished panelists to this hearing. Let me say in the outset, and I know you know this, but just last week I and so many other members were at the funeral of Don Payne, who had a deep compassion for the people of Northern Ireland, and he will be deeply missed. The funeral was actually 5 hours of memorials by some 30 individuals, including President Clinton. So it was a very, very meaningful funeral, and he will be missed. In addition to his work there, I would note parenthetically that I chair the Africa Global Health Global Human Rights Committee, and he served as my ranking member. And when the Democrats had control, I served as his ranking member. So we exchanged seats several times and worked very, very well together, and he will be missed. Let me just, today's hearing is called Northern Ireland, Why Justice in Individual Cases Matters, and was likewise, our purpose today is to assess the progress made in Northern Ireland to date with a focus on what more can be done to ensure that peace is self-sustaining, that people can reconcile their differences to build a better future together, and that justice ultimately prevails. This takes a 100% commitment, not a 60 or an even 80% commitment to fulfill the promises made. While there has been much progress, I believe that the unfulfilled British commitment, broken commitment unless the British government reverses course, in the Pat Finucane case is threatening the consolidation of the peace process. In connection with the Good Friday Peace Agreement, the British government promised, as we all know, to conduct public inquiries into the Finucane and other cases where collusion was suspected. Subsequently, the British government has backtracked in regard to the 1989 murder of human rights lawyer Patrick Finucane, despite the recommendation, which again the British government agreed to abide by, of the internationally respected jurist and former Canadian Supreme Court Justice Peter Corey back in 2004. I note parenthetically that Judge Corey, testified on 2 occasions before the Commission and before my subcommittee, and he couldn't have been more emphatic as to how integral it was that justice and an absolute public inquiry be followed in the case of Patrick Finucane than he was. I mean, he articulate and very, very educated and very incisive in his words. He repeated it over and over again and said, there's no other option, there's no other choice than to do the public inquiry. The deliberate decision not to proceed with a public inquiry is glaring, public breach of faith. It is a source of enormous frustration to Pat Finucane's family and to his many friends. It resonates throughout Northern Ireland, calling into question the British government's commitment to peace and reconciliation. This is particularly sad because the British government has taken so many other positive, truly honorable steps, many of which were painful for large sectors of the British public and official opinion, such as the Bloody Sunday inquiry released in 2010. To call all of that into question by reneging on the promised Finucane inquiry is a tragedy. The British government has admitted that it did collude in the Finucane murder, yet resolutely blocks any public inquiry into the collusion. The question asks itself, after so many positive steps, is the British government really going to diminish the good it's done since 1998 in order to protect the identity of people who share responsibility for this heinous crime? In closing, I'd like to thank the Irish government for its plans to promote the Northern Ireland peace process as a case study for addressing conflict situations and post-conflict reconciliation elsewhere in Europe. Last month, the Irish Foreign Minister, in his capacity as the chair in office of the OSCE, testified at a hearing of this commission about these plans. Despite some of the problems we are going to talk about today, there has been real progress on the ground in the north of Ireland, due also to the goodwill of the people on the ground. We have an excellent panel of witnesses today to update us on developments and provide useful suggestions for further action. First, we'll hear from Geraldine Finucane, the widow of Patrick Finucane. Geraldine was there, along with her 3 children, when assassins entered the Finucane home and took her husband's life. We are grateful for your presence here today, Geraldine. It's so great to see you again. You have been here before, and you have, with great grace and great courage, admonished all of us, including the U.S. Congress, the President of the United States, and certainly the government of Britain, of the U.K., to finally, at long last, do a public inquiry and get to the bottom of the truth rather than engaging in cover-up. Next, we'll hear from Christopher Stanley. His extensive experience as a lawyer and currently with British Irish Rights Watch has made him an effective advocate and an expert on penal policy reform and the Bill of Rights for Northern Ireland. We look forward to his insights and recommendations this afternoon. And finally, we'll hear from Mark Thompson, who is Director of Relatives for Justice, who will describe for us the impact justice can have on healing the wounds of violence in Northern Ireland, and what happens when justice is not forthcoming and those wounds are left open and exposed and festering. I'd like to now yield to Dr. Burgess, one of our fellow commissioners on this Helsinki Commission.
Thank you, Mr. Chairman. Thank you for calling the hearing. In the interest of time, because I know we're going to have some floor activity coming up shortly, let me just submit for the record and we'll go right on to our witnesses.
Thank you very much, Dr. Burgess. I'd like to now turn the dais to, or the time to Geraldine Finucane, for which time she may consume.
May I start by reminding everyone just how difficult it has been for everyone in Northern Ireland to reach our present position. Can I remind you all of those difficult days when there was extreme diversity on how to reach peace, when not everyone was committed and when compromise was very hard? I ask you to remember all that because it plays such an important role in how we continue to move forward. Everyone worked so hard and gave so much. It is important that what was promised is delivered. Otherwise, people will feel all the work has been in vain. That is why I think the title of this hearing is so appropriate. There are many prerequisites, but I feel it is very important that commitments made during all the negotiations are honoured. As this committee knows from previous testimony, a commitment was made to my family following talks between the British and Irish governments at Weston Park. Under this agreement, an international judge was appointed, Mr. Justice Peter Corey. He was tasked to review 6 cases, including that of my husband Patrick. Both governments agreed to fully implement his recommendations. Although Judge Corey did recommend a public inquiry into Pat's case, there has been nothing but delay. Publication of the report was delayed, the announcement of the way forward was delayed, and eventually the law was changed to the New Inquiries Act 2005. This Act has one important section which provides the relevant government minister with power to override the tribunal by issuing restriction notices. In my eyes, and also in Judge Corey's eyes, it removes independence from the tribunal. This section of the Act provided my family with a great dilemma. We felt we only had one chance at an inquiry into Pat's murder and the encompassing circumstances, and we did not feel this law would let that happen. The Labour government even drew up a restriction notice under which a tribunal would have to operate, and that was before a panel had even been considered. It caused a stalemate for many years. The Labour government never seemed willing to break the logjam, but were happy to let time pass and blame us. Following the change of government in 2010, we were asked for a meeting by the new Secretary of State, Owen Paterson. In November 2010, my son John and I listened to him tell us his government was committed to resolving this case and move it forward. Delay suited no one. We were encouraged. What followed was an engagement between my family, our legal team, and representatives of the British government. John and I met with the Secretary of State in Belfast and here in DC, and lawyers for my family, including both my sons, attended meetings over the course of last year with the Secretary of State and his officials. Most of these meetings were private in order to facilitate open discussion. The process was part of a review by the government to determine whether a public inquiry remained in the public interest. The government wanted to know if we would participate in an inquiry, and if so, under what conditions. Our objection to part of the Inquiries Act is well documented. We opposed the use of restriction notices, as I have explained, because a government minister can impose these upon an inquiry at will. We had asked the previous government not to use them, but they would not agree. However, a recent case, the Bahamusa inquiry, created just such a precedent. Restriction notices were not deployed, and decisions about the restriction of evidence was left to the independent judge. We told the government that an inquiry operated along similar lines would be something we could participate in. Indications from the government officials were very encouraging, and at no time were we advised that an alternative to an inquiry was also under consideration. Lest there be any misunderstanding, we committed our position in writing in a submission delivered to the government. As it makes clear, the focus of the discussions between our family and the government was the manner in which the inquiry might proceed. It was the government itself that brought the Bahamusa inquiry into discussions as a model to promote progress. A considerable amount of time was spent exploring how it could be utilised as a blueprint for my husband's case. At no stage was a review in the manner that was subsequently announced by the Prime Minister ever discussed. Following the conclusion of our engagement with officials, we learned in late summer 2011 that the Prime Minister, Mr Cameron, wished to meet with us in Downing Street. We were encouraged by this invitation, and speculation was intense that the government was finally to honour its commitment to a credible inquiry originally announced in 2004. Furthermore, in a telephone conversation between a senior NIO official and my lawyer, Peter Madden, we were told that the Prime Minister wished to speak with us personally and was confident we would be happy with what we heard. We assumed this confidence would be a reflection of our position that had been clearly outlined during the preceding 11 months. We could not bring ourselves to believe that we were being invited as guests to the Prime Minister's home just to be refused the public inquiry promised so many years ago. That David Cameron did so, and in such a public fashion, ranks as one of the most cruel and devastating experiences since our campaign began. Not only were my family and I forced to listen to the Prime Minister renege on a promise made by the British government, we had to hear him tell us over and over what it was we really wanted, how we really wanted to achieve it, and what our ultimate response would be. It was clear that we had been lured to Downing Street under false pretences by a disreputable government led by a dishonourable man. We felt humiliated publicly and misled privately. What Mr Cameron has established is a review of the papers in the case. The person appointed, Sir Desmond de Silva, will simply read statements collected by the Stevens investigation team. Although he will be permitted to speak with relevant persons, this will all be done behind closed doors. My family is not permitted to participate. We, or indeed anyone, will see nothing, hear nothing, and say nothing. If anyone refuses to cooperate with Sir Desmond, he has no powers to compel or sanction them. My family and I, and indeed many others in Northern Ireland, have no confidence in this process. We cannot be expected to take the British Prime Minister's word that it will be effective when he is reneging on a government commitment in order to do it. People are now asking the question, if the government are unwilling to deal with the Finucane case in an open, thorough, transparent manner, what are they going to do about all the other issues that need dealt with? The case of Pat Finucane shows that promises of the British government can be easily broken, and that their desire to help Northern Ireland is half-hearted at best. This will impact deeply on Northern Ireland and how everyone moves forward. Collusion affected everyone, and indeed continues to do so. Unless the depth of it is exposed, no one will lose their suspicions, confidence will remain undermined, and no one will be able to settle to a stable future. My son John and I are in DC once again I am testifying, And once again, I wish to thank all of our supporters in Congress and the US administration. At this point, I would like to pay tribute to Representative Donald Payne, who died recently. Donald was a politician of a truly inspirational kind, dedicated to human rights domestically and internationally. Personally, a kind and generous man. He supported my campaign for many years, and for that I am truly grateful. He will be sorely missed, and my condolences and that of my family go out to his family at this time. I thank the committee for holding this hearing on a subject that is so important and relevant to the current issues in Northern Ireland. Collusion is a nasty strategy which did not discriminate on religious or political grounds. There is no doubt that if progress is to continue in Northern Ireland, dealing with my husband's case is an absolute prerequisite. Thank you very much.
Mrs. Finucane, thank you so very much for your eloquent, as you have done so brilliantly in the past, asked for simple justice, simple transparency, openness. And it does beg the question, once again, what is it that the government is hiding? Why is there a cover-up? You know, Judge Corey, when he testified and when he refused to and admonished any jurist or law enforcement official from being involved with what would be a truncated investigation, said, I mean, you go wherever the information takes you. And if it fingers people who may perhaps be in high places, then so be it. Eventually, this information will come out. Nothing ever remains hidden or dormant or under the table forever. But it does beg the question why, through successive governments in the UK, we have had this unwillingness to follow up with the clearly stated agreement that led to the Good Friday Agreement. And one of those provisions included a public inquiry into the murder of your husband, Patrick Finucane. So I think, and I can say this without any fear of contradiction, our commission, and I know many members of Congress, both sides of the aisle, will continue to push hard. But it has now gotten to the point, and again, as you pointed out, to be lured to 10 Downing Street, you know, the cruel and devastating information that was conveyed to you by Prime Minister Cameron, the reneging on what you thought was going to be good news, and then the government reneges and dishes a very, very bit of awful news that only brings, I would respectfully submit, dishonor and suspicion upon the government. And that, again, is both Labor and Conservative, because it seems not to matter. But it does beg the question, what is it that they are hiding? Why the cover-up? I'd like to yield to my friend, Dr. Burgess. We do have some votes that came as you were speaking. We will take a brief...
Why don't you go ahead and vote?
Okay, we'll come back. But again, Mrs. Finucane, I want to thank you for your valiant defense of your husband, who we all deeply grieve for the loss of him. You know, many of us got to know him after the fact, and the tremendous work that he did as a defense attorney. And certainly John, your son, who is here in the back, who has testified himself. You know, what a legacy of a family that absolutely will not be deterred in getting the truth and for fighting for human rights for all. I remember Rosemary Nelson said before she was assassinated that who could forget Pat Finucane and the chilling message that sent to every defense lawyer throughout all of Northern Ireland. And yet she stood strong as well and paid the ultimate price when she was murdered in that terrible, terrible car explosion, which was obviously another investigation that was required. So thank you, Geraldine. You are an inspiration to each and every one of us. You are a true human rights warrior and a champion, and we are all indebted for your courage and bravery and your clarity. How could any lawmaker, prime minister, president, member of Congress hear your words and not be moved? So thank you. We will stand in brief recess. The commission will resume its sitting, I should say, and I'd like to apologize for that rather lengthy delay, and I would like to go to our second witness. And again, Geraldine, thank you for your testimony. Several members did indicate they will be coming by, so hopefully that'll happen shortly.
London. We're in the vicinity of Westminster. Thank you. I'm grateful to this Honourable Commission for allowing us to give testimony to its hearing on prerequisites for progress in Northern Ireland as a forum for following up and developing the themes of the previous US Helsinki Commission hearing of March 16, 2011 on Northern Ireland, why justice in individual cases matters. We request that our longer written testimony be entered into the record of the Helsinki Commission.
Mr. Stanley, without objection, so ordered.
Thank you. And we'd also welcome the opportunity for the evidence given in written form by the Finucane Centre, by the Committee on the Administration of Justice, and by Dr. Patricia Lundy of the University of Ulster, also to be accepted into the written record of the Helsinki Commission. Thank you.
Without objection, so ordered.
Thank you. We wish to thank the Chair of the Helsinki Commission, yourself, Representative Smith, in particular for your long-standing interest in human rights in Northern Ireland. And BRW would also like to take the opportunity to mark the recent passing of Representative Donald Payne, although not a member of this commission, as has been noted, but with an abiding interest in bringing peace and human rights to Northern Ireland, and we send condolences to his family. In this oral testimony, BRW, British Irish Rights Watch, outlines what we consider to be the actions that still need to be taken to complete the peace process and address potential implications of a failure to take these actions on the situation in Northern Ireland. What we said last year still stands, as unfortunately little or no progress has been achieved. And in some instances, particularly in relation to the case of the murder of Patrick Finucane, there has been regression in terms of no progress. We also have, and I'll talk about this later, and it's what my colleagues will also address, deep-seated flaws and problems with the available mechanisms of dealing with the past in terms of a police ombudsman's office, which is seriously undermined, and an historical inquiries team, which is actually part of the police. So it's a question of who guards the guards. The past in Northern Ireland cannot be ignored and continues to shape the present and to determine the future. One of the reasons for this is that although there have been many victims on all sides of the community, many people still do not know why their loved one died or they themselves were injured. Many lies have been told, particularly about state collusion in killings. There's a great thirst for the truth, particularly as people emerge from the shadow of the conflict and are empowered and confident enough to ask difficult and uncomfortable questions about what happened and why no one has been held accountable in so many cases. Therefore, our first prerequisite continues to be the introduction of an effective human rights compliant mechanism for dealing with all the unresolved individual cases arising from the conflict. This mechanism would be independent of the British state and would accord with the elements required for the discharge of human rights violations identified in international law, and particularly of the jurisprudence applicable to the UK as a signatory of the European Convention on Human Rights. One of the implications for the continuing failure to introduce such a mechanism will be that the past will continue to cast its long shadow across Northern Ireland's future and make it more difficult to achieve the peace and stability that Northern Ireland so badly needs and so greatly wants. We again respectfully request this Honourable Commission to seek an assurance from the UK Government that it will establish such a mechanism without further delay and in consultation with victims, human rights experts and others. Truth recovery mechanisms do exist, as I've just said, in Northern Ireland, having been developed mostly as a result of the Good Friday Belfast Agreement, and we and other civil society organisations engage with these mechanisms to assist our clients. Sometimes these existing mechanisms are able to offer what is needed. However, in some core aspects, the mechanisms are flawed, especially in regard to their independence of the state, which is so often under scrutiny for its role in the conflict. We and others, including our colleagues at this hearing, do not shy away from our responsibility to point out the flaws in the available systems and advocate for their reform as a second prerequisite for progress in Northern Ireland. All parties to the conflict cannot avoid the political, legal and moral obligations arising from the killings and injuries and other forms of loss that occurred at that time. It is a time not too distant, 1969 to 1998, within our lifetime. It is recent history, but should not be treated as historical. The 9th to 11th of August 1971 is not historical to those families of the victims of the Ballymurphy internment massacre. The 12th of February 1989 is not historical to Geraldine Finucane and her family. The 15th of August 1998, after the Good Friday Belfast Agreement, is not historical to those victims and the families of the victims of the Omagh bombing. There can be no progress here unless truth is exposed and confronted by all those responsible and dealt with in the form of redress arrived through consensus. And finally, a third prerequisite for progress is therefore not consigning this past to history. This is not history that can yet be analysed by historians or archived in some form of collective memory and filed as forgotten, or even worse, dealt with. That simply will not do. Despite the apparent political will to do so, this history is too fresh and live to be written, but must be the subject of anxious scrutiny of judgment. This is why the promises, obligations and expectations made in domestic and international agreements in places such as Stormont, Weston Park and St Andrews must be fulfilled and not reneged upon. Those outside Northern Ireland must realise that the peace is fragile because the wounds of the past have not been healed. London, Dublin and Washington continue to have obligations here, despite the UK's protestations about devolution. The Bill of Rights for Northern Ireland in the Good Friday Belfast Agreement is now moribund and conflated with a national political agenda. The Western Park Agreement has failed to deliver what is required by the family of Patricia Finucane, and so forth. Broken covenants do not ensure progress within a society. Northern Ireland, having come so far, deserves and expects more, and the honouring of promises is a fourth prerequisite for progress in Northern Ireland. And that's our testimony. Thank you, sir.
Mr. Stanley, thank you so very much for your testimony, your very specific recommendations. As you know so well, Jane Winter in the past has been before this commission and before the Human Rights Subcommittee, and you continue that very extraordinarily fine tradition of presenting incisive recommendations, and I thank you for that.
Thank you, sir.
I'd like to now recognize Mr. Thompson.
Thank you, Mr. Chairman, for the invitation and opportunity to address this very important hearing. I, too, want to put on the record and recognise the passing of Congressman Donald Payne. We had the privilege of hosting him at Relatives for Justice on 2 occasions in Belfast, and it was a great honour. I'll begin my testimony. 18 years on from the first cessations of violence in the North, and 14 years on from the peace agreement, our society has undoubtedly been transformed for the better. The sharing of power by traditional political opponents, once unthinkable, is as natural a thing as if it were always the case. We have much to be thankful for, especially those of us who have been so adversely affected by violence. Many observers of Irish affairs could be forgiven for believing that this somehow signifies that everything has been resolved and that the focus, the concentration once given, is no longer required. However, this could not be further from reality. Arguably, the most contentious issue of who did what to whom during the conflict, that of responsibility, culpability and accountability, requires addressing in a structured, resourced and independent way. The failure to do so thus far casts a shadow not only over the lives of many of the victims and survivors, but also society too. The hurts of the past are as present as the past is. Hardly a week goes by without mention in the mainstream media and within civil society of an atrocity whereby the bereaved and injured of all persuasions give public voice to their experience and for resolution of human rights abuses. Families are seeking truth, acknowledgement and recognition of their loss and injury. They are now telling publicly what for them were once unspeakable truths. They are breaking the silence after many years and have taken courageous steps towards addressing injustice. All parties to the conflict have been rightly confronted and challenged by these developments. The bereaved and the injured bear witness, testimony, and now seek answers. The past week, I have been part of a delegation of relatives visiting the US that have witnessed the murders of 15 of their loved ones and the injuring of 14 in 3 separate incidents. As part of this important hearing, I request to place into the record reports carried out by relatives for justice into these killings.
Without objection, it will be ordered.
These particular killings present challenges for the British authorities, and as a sovereign government, there are certain standards and legal obligations that must be met. Institutional avoidance, prevarication and obfuscation sum up the official response to these killings, and perfunctory processes exist that are presented as models for resolution by a British Secretary of State who has abdicated his government's responsibility concerning acknowledgement and accountability. These predictable outcomes, the result of vested interests, underline the internationally accepted norm that those responsible for violations cannot examine those same violations. No doubt the British government will present that the PSNI are one of the most regulated police services in the world. They will justify this with the oversight role of the police ombudsman, and that the PSNI's historical inquiries team is a unique initiative reviewing all conflict-related deaths. However, scratch the surface and much is revealed that tells a very different story. Former RUC members, including members of Special Branch, have been re-employed by the PSNI to work on legacy cases and are employed as civilian workers. In this capacity, they are thus unaccountable to the Police Ombudsman's office. The HET has also recruited a significant number of former RUC members within its ranks. They too avail of this technical loophole and are unaccountable to the Police Ombudsman. And even within the PSNI's own legacy unit, a former senior member of Special Branch has been employed as a civilian person who vets material that goes to the courts and to inquiries and to inquests. Effectively, the role of the Police Ombudsman's Office has been hollowed out in respect of its retrospective remit examining legacy cases. The bereaved and the injured of the conflict, from all experiences and backgrounds, want the truth. They want validation of being wronged rather than vilification for standing up and speaking out. The British government has sought to make standing up for justice a negative concept. We live with the legacy of impunity. Challenging impunity is a necessary prerequisite to rebuilding a society and in creating the promotion and protection of human rights and in the administration of justice. In a recent report by the World Bank, they linked development and security to justice. Truth informs positive change and reform. Justice is the bedrock of democracy. People are dying without truth and without justice, and we owe it to them to collectively address the legacy of the past in a progressive way that delivers truth, accountability, and transitional justice that consolidates the peace and heals the wounds. We also owe it to future generations. The cost of not doing so is too great. The quote, "Those who forget the past are condemned to repeat the past," has never been more present. An independent international truth commission could potentially provide the best opportunity for truth recovery for the greatest number of people affected by the conflict. Such a process must be underpinned by key values and principles, including those of independence and inclusiveness. Narrowing the permissible amount of lies, securing the truth, transitional justice and accountability is the only fitting memorial to those killed and for those injured. All of the key issues within the peace process have required an international role and remit. Dealing with the past is the last piece of the jigsaw of the peace process and arguably the most contentious and challenging. We require international assistance and not perfunctory processes that politic, that conceal and prevent the truth from emerging. No government, no organisation, no party to the conflict with a vested interest in the outcome should determine, lead and drive processes that address past violations. Rather, they should be subject to a process which is independent. The reality is that children are growing up with a narrative of injustice rather than a narrative of hope. The issues are far from going away. If anything, they are growing and they will not be brushed onto the carpet. Mona Ashwari, UN Assistant High Commissioner for Human Rights, recently said, "People don't forget. They keep their loved ones close. Facing the truth is the only option. We need to face the past and the unpalatable truths, otherwise they will have a negative and corrosive effect on our body politic and throughout civil society. Individual, communal and societal healing, recovery and reconciliation can only take root within the context of such a process. We will be a stronger and a better society for it. Thank you, sir.
Thank you very much, Mr. Thompson. Very, very disturbing information that you've conveyed to the Commission that needs to be further investigated by us, by others. So I will get to that very shortly. But we've been joined by Elliot Engel, a good friend and colleague of mine. We both serve on the Foreign Affairs Committee together, and he's been very active in all things related to Northern Ireland for years. Congressman Engel does have to catch a plane, but I'd like to yield to him for any comments he might have, and then invite to the witness table 2 additional witnesses without objection for comments from them, and then we will go to some additional questions. Congressman
Engel. Well, thank you. Thank you, Mr. Chairman. I just wanted to come here, even though I have a plane to catch, to show my solidarity and strong support for what our people are testifying here for today. Geraldine, welcome. It's always good to see you. Mrs. Finucane, welcome, and to all the other panelists as well. My good friend Malachi McAllister, also. Please know, as you already do, but I want to state it publicly for the record, that there are a lot of members of Congress on both sides of the aisle that are very sympathetic to what you have to say. I think while we move forward with the Good Friday Accords and then move forward, we should not use the Good Friday Accords as an attempt to sort of paper over everything and say everything is just hunky-dory, everything's right, put everything behind us, and let's move on. I think we can only move on when the truth is finally told, when people who are culpable admit their culpability, or when people point out exactly what happened. While I welcome the British Prime Minister's apologies for Bloody Sunday and think it took a lot of courage for him to say it, there are more things that need to be said. There are more things that need to be done. There are more things that need to be looked into. And so I just wanted to come here. I have, which was given to me, and I'm reading it on Friday, on Sunday in my district in Pearl River, New York. This atrocity pamphlet, this ambush, assassination, and impunity pamphlet, and this massacre collusion pamphlet. These are things that I believe that all of our colleagues, Mr. Smith's colleagues and my colleagues, should have, and I hope we can get copies for every member of Congress so that they can read. It's easy reading. You know, it's not something that's 1,000 pages and you got to go through it and whatever. It's very short and very succinct. We know atrocities were committed. No one disputes that. And we also know that there were cover-ups, and no one disputes that. And we all know that there was collusion within the highest, perhaps, levels of the British government, along with some of the paramilitaries. I think that it helps to get to the bottom of it. I think if peace and justice is to prevail, we need to know what really happened. And I just want to assure all of you that Mr. Christopher and Mr. Stanley and Mr. Thompson and Mrs. Finucane, I want to assure you that I will not rest. I will leave no stone unturned. Look with my good friend Congressman Smith, who you know will leave no stone unturned, and there are others with us who will leave no stone unturned until we get to the truth. You know, Malachi, there's a picture here showing Graham, I think it is. It's the shop here, and Malachi was telling me the other day that he lived down the block and in South Belfast. I also, by the way, mentioned this to Jerry Adams yesterday when I had the occasion to talk to him. I think the United States Congress played a major role in trying to bring peace and justice to the north of Ireland, and I think the United States Congress still has a major role to play, and I just want to assure you that I will continue to play that role. I'm sorry I have to run. I mean no disrespect. I wanted very much to come in. In fact, I had my office get me a later plane because I didn't want to miss coming here, and just to tell you that you have my 100% unequivocal support, and Chris Smith and I and others are going to work together to get to the bottom of all of this. Thank you, and God bless. Thank you, Mr. Smith.
Thank you, Mr. Elliott Engel, good friend and colleague, for being here and for his wonderful work on behalf of Northern Ireland. I would like to welcome to the witness table Brian Gormally, Director of the Committee for Administration of Justice, AOJ. I would note parenthetically that, on my trips to Belfast, often would meet with AOJ, would get timely insights as to what was happening on the ground, as well as far-reaching recommendations as to what I and other members of the U.S. House and Senate ought to be doing. And in the past, AOJ representatives have testified before both my subcommittee and the Commission. Thank you for being here. And Patricia Lundy, who's a senior lecturer at the University of Ulster and has done tremendous amounts of research on the historical inquiries team, if she could join us as well and present their testimony, beginning with Mr. Gormally.
Thank you, Chairman, and thank you for the opportunity to give a very brief oral presentation to this important Commission. May I also associate myself with the sentiments about the untimely death of Representative Payne. I didn't have the privilege of meeting him myself, but his contribution to human rights in Northern Ireland lives on in CAJ's institutional memory. I just want to briefly talk from a human rights perspective about the continuing breaches in Northern Ireland. We have made a huge amount of progress, but as has already been apparent, there is unfinished business and also attempts to roll back some of the advances that have been made. The UK is a signatory to the European Convention on Human Rights, and Article 2 of that convention promotes and guarantees the right to life. Recent jurisprudence in the European Court has held that, amongst other duties, a state must properly investigate any apparently unlawful killing, especially where state agents may be involved. An investigation must be effective, prompt, transparent, and independent, and also involve the next of kin to the extent necessary to protect their interests and their rights. In CAJ's opinion, the United Kingdom is seriously in breach of its European Convention, Article 2, responsibilities to protect the right to life in respect of cases where state involvement in unlawful killing is alleged. In a number of high-profile cases, including the Finucane case, it has refused to carry out proper investigations into possible direct or collusive involvement in killings. And it will be apparent from the list of criteria that I read out that the so-called review that the British government has offered in the Finucane case does not meet international human rights standards for investigating an unlawful killing. In our view, this is not a matter of the past, but of the protection of the right to life in the present and the future. The reality is of a major Western government failing to put in place the investigative and regulative mechanisms necessary to prevent its agents from engaging in extrajudicial executions or other unlawful killings. We are deeply concerned that this failure is leading to a culture of impunity amongst British military, intelligence and security agencies, and may result in their further involvement in unlawful killings. There is also evidence that the failings by the UK government give cover and encouragement to those states, including Council of Europe members, engaged in much more egregious human rights abuses. These cases arising from the past in Northern Ireland are therefore vital to pursue for all those who care about human rights and the responsibilities of major Western powers to take their lead in their protection and promotion. There are various mechanisms that can currently be used in Northern Ireland to investigate past unlawful killings that might involve state collusion. However, none of them at the present time meet fully the criteria that the European Court has set down. And we support the call that Mark Thompson has made for a comprehensive way of dealing with human rights abuses and other atrocities in the past in Northern Ireland. Without that, the peace process is still at risk. I just want to mention briefly the extent to which the Office of the Police Ombudsman has been subverted over the past few years. It's an office that we fully support. It is one of the most powerful police complaints mechanisms in the world, and has a duty also to investigate past cases where police misconduct may have been involved. I won't go into detail. The evidence that I've given has been kindly put in the record, but at the present time, we have to say that the Police Ombudsman's Office, just like the Historical Inquiries team that Patricia Lundy is going to talk about, are not able to properly carry out the UK's obligations to human rights, and in particular, the right to life. The right to life is the most important human right, and we could argue that the government's foremost duty is to protect it. While there have been huge advances in Northern Ireland, and human rights, including equality, are better protected than ever before, the lack of effective investigations into unlawful killings is a dangerous gap. It has the capacity to undermine the peace process and to weaken confidence in policing and the new society as a whole. Although these cases happened in the past, this is not a historical question. It is a matter for the present and for the future. It's a central human rights issue. If we cannot trust the government to fully investigate cases where its agents may have killed citizens, what can we trust it with? Thank you, Chairman.
Thank you very much, Mr. Gormally. I'd like to now yield to Ms. Lundy.
Thank you. Thank you, Mr. Chairman, for the opportunity to present my oral testimony. My testimony is based specifically on the Historical Inquiries team. I was granted access to research the HET by Hugh Ord, the former Chief Constable. And for 3 years, I observed the day-to-day operations of the Historical Inquiries team. I also had access to all the members of staff and also to documentation. Part of that research also involves interviewing families and also analysing the reports which the HET delivered to families. So I think I have a fairly good overview and insight into the Historical Inquiries team. What I would say is the British government's approach to dealing with the past has been a very fragmented approach, a piecemeal approach. But I think that the picture that is painted at the moment is one where there is progress, where there is a package of measures and those measures are actually working, they're delivering for families. But I would suggest that my own research and also information from NGOs and lawyers would indicate that the package of measures, aspects of it, are not working. They're not Article 2 compliant. So I will give you some detail about my own research and the concerns that it raised. Initially, the research considered independence, and my research found that there were large numbers, I suppose, in a sense, of former RUC officers employed in the HET. But significantly, those individuals that had responsibility for control of intelligence were former special branch officers. So the entire intelligence unit was made up of former special branch officers, and they acted in a gatekeeping role. So I would suggest that the HET is most certainly not independent. It is the police investigating the police. But I think it goes a wee bit deeper than that even. I felt that the process actually delimited access to the truth for some families. I felt that the families had to ask the right question. If you didn't ask the right question, you didn't get the answer. I also found that if a family was represented by an NGO or a lawyer, that the quality of their report was significantly better. But my most recent research, I think, raises even more concerns. And this is a piece of research which focuses on the actual reports that were given to families. And it deals with the military cases, 157 cases, which are usually referred to as RMP cases, Royal Military Police investigations. And really just to cut a very, very long conversation down. These cases were never properly investigated at the time. There was an arrangement or an agreement between the RUC, Chief Constable at the time, and also the GOC of the British Army, that the Army would investigate and interview the soldiers, and the police would interview civilians. And really what happened at the end of the day was those cases were never investigated by the police. So it's 157 cases which have never been investigated. So this is now on the desk of the HET, and I have analysed a number of the reports and the re-examination of those cases. And what I can tell you is there is a difference and a differentiation in treatment between the cases of the military and paramilitary cases. Now, I can list the evidence to back this up. It's about pre-interview disclosure, it's about verification of illness, it's about the robustness of the actual interviews that take place. And the HET, surprisingly, have also introduced what's called a pragmatic approach. And the pragmatic approach is that they will interview the suspect, the soldier, but not under coercion. And really what this is an informal interview, which actually goes back to the initial complaint, which was the informal interviews carried out by the RMP. The HET's justification for the pragmatic approach is if you interview someone under coercion, they are likely to be more guarded and they will not give any information. They will not be forthcoming with information. So it's quite an unusual practice, I would say. And I think it's something which a Truth Commission perhaps does, but the HET is not a Truth Commission. It does not have the powers. It does not have the power of amnesty or immunity, but it's behaving as if it is a truth recovery process. So I would suggest that in the 157 cases, there are anomalies, there are inconsistencies, and I believe that this raises serious questions about the impartiality of the HET and the effectiveness of its investigations. So I believe that it is certainly not Article 2 compliant in terms of independence, effectiveness and transparency. There's a lot more that I could talk about, but really this is really a very quick summary of the main concerns that the research has raised.
Serious problems that remain unattended to, and I thank you for bearing witness to those concerns in such a comprehensive and with such precision. Each of your testimonies are truly disturbing. The deterioration, the backsliding, the raft of concerns that you raise require our commission to really redouble our efforts to get answers, to ask the tough questions, to try to hold to account, to do our part, if you will. We are going to do a letter, and I expect to have numerous members sign it, which even in reviewing your testimonies will be an eye-opener. Unfortunately in Congress, and I'm sure it's in every other parliament or Congress around the world, the issue du jour, whatever the crisis might be, often crowds out long-standing problems that, if unredressed and if not investigated, do fester and lead to an impunity that some of you have spoken about. So we will ask, and I'm not sure he'll respond, but we'll ask the UK ambassador to the United States, if he would like to testify. One of the, unlike standing committees of the Congress, or at least of the House, we routinely ask and have ambassadors come and testify before our commission in order to ask real questions in total sincerity, hoping for and expecting real answers. So we will issue an invitation to him to see if he'd like to come and testify and answer some of the profoundly disturbing questions that you have raised today. We know that Prime Minister Cameron was recently here. I'm not sure, matter of fact, I would bet my salary that President Obama did not raise issues like the Finucane case or any others. I would have hoped that he would, but he did not, or at least I would love to be corrected on that. In reading some of the British tabloids, they certainly gave great details about how close and friendly they were. I mean, the state dinner and the toasts and everything else couldn't have been more cordial, and certainly we want good relations with every country, including our friends in the UK. But there needs to be, issues past, which are really issues present, addressed. And so thank you, each of you. I mean, this testimony this is my 14th congressional hearing on human rights abuses in Northern Ireland, backed up by a number of visits, and I met many of you, especially Geraldine, on each of those trips. But this really injects a cautionary note that things are not getting better. If anything, the idea that RUC and others, special branch, would be recruited and hired to run interference. I think, as you put it, the gatekeepers, Ms. Lundy, the gatekeeper, I mean, that begs the question as to how many, we know of the big cover-up, or at least believe there's a big cover-up, massive cover-up with Geraldine Finucane's husband's case. But how many other cover-ups, small and intermediate and large, are occurring every day as information is just thrown away that otherwise would be actionable and very embarrassing. So your testimonies, like other hearings, but maybe more than other hearings, because this one, people keep expecting, oh, Northern Ireland, everything's fine there. It's not so fine, and we need to redouble our efforts. I plan on doing a resolution that will focus on the Finucane case. I've done that in the past. It has passed the House, putting all of us on record, generating a robust debate on the floor of the House. But I think we need to incorporate many of the very significant issues that you've all raised today, and again, I thank you for that. So much has to be done. The key is in the follow-up. You've presented evidence that begs action, so thank you for that. I would like to ask Geraldine, if you could, Mrs. Finucane, if you could just further elaborate on what it was like when you had that visit with the Prime Minister. I mean, you couldn't have been more clear about your reaction to it, but you thought you were going there to receive good news, only to be disappointed once again.
Yes, we certainly did. And I do have to say that when the meeting started in Downing Street, Mr. Cameron started extremely well by saying it was a terrible crime, something that shouldn't have happened. He pointed out that he was only 46 or 47 years of age, and he hadn't been in politics at the time, so he wasn't going to tread on anybody's toes. He admitted that there had been state collusion in my husband's murder, and he said that he felt it was necessary to find out how high up the chain of command that actually went. That was the start of the meeting, and I was sitting there thinking, this is absolutely superb. This is a recognition, a government official position on collusion, marvellous. And he then went on to announce the paper review in which we would have no input at all. As you can imagine, the arguments put forward by myself and the rest of the family were very strong. Mr. Cameron did not seem to have any reply to this and seemed to get rather frustrated and flustered during the meeting. Indeed, when John was asking him a question at one point, he sort of gestured and pointed out round the windows outside and said, you know, there are people in Whitehall who will not let me have this inquiry, so this is the best there is on offer. Rather a shocking statement. I really would like to know what he means by that.
Great question. You know, Mr. Stanley, how do the British people feel about a public inquiry that was promised, that was absolutely part of the Good Friday Agreement? Are they angry? Are they worried about what the government might be hiding? Could you put that?
I think there is an anxiety in many levels of British society about power in the UK and who holds power and the relationship between the executive and democracy and the erosion of that relationship. It's partly in response to recent cases which we've tried to bring as analogous to Patrick Finucane's case, where the British state has been held to be found accountable for torturing Iraqi civilians, for example, and has had public inquiries into those atrocities in Basra and so forth. That's the model which now that Geraldine and her family would accept of a model of inquiry. But for those truths to come out about incidents in 2003, about breaches of Article 2 and breaches of Article 3, which received very extensive press reports, and then you have the extensive letdown of a family being invited to Downing Street by the British Prime Minister to be told, we're going to do a behind the paper, we're going to be a behind the doors secret investigation of a paper review for the third time, is simply not acceptable. And I think the British public, even though not directly, but I think there is a concern about this response to the abuse of power by government and by the executive.
Anyone else like to respond to that? You know, the subversion of the Office of the Police Ombudsman, which was included in your testimony, let me just ask you, you know, we had Christopher Patton testify at one of my previous hearings. I remember at the time the biggest concern that I raised to him was the grandfathering or of bad apples, as he called them, the people, particularly in higher positions, who would not be gone after. There were a lot of good things, obviously, the creation of the new police service. There were many real reforms, and we certainly, I and others, you know, showered praise upon that part of it, but again, others were grandfathered in, if you will. But the PNCI, or the police ombudsman, was created, you know, from those reforms. Are there people like Patton and others who are upset with the subversion of that office?
Well, I think...
are they aware of it?
Well, yes, I think they are, and the person most upset, I would suggest, was the previous police ombudsman, Baroness Nuala Olone. And she has now publicly criticised the subversion of that office. I mean, what has happened is that the powers, the legislation that established the office are good and certainly capable of conducting a human rights compliant investigation into unlawful killing. But over the past period, we have had interference by the government in the appointment process of the last ombudsman. He wasn't given proper security vetting. There are problems with the relations of the ombudsman with families, so the whole question of involving the families, this is since Nuala Olone left and the current ombudsman took over. He has redrawn or failed to use the definition of collusion that Judge Peter Corrie developed, which is a perfectly adequate and broad definition, so that he points to a list of failings by police or incompetence or evidence being accidentally destroyed, facts that all put together would add up to collusion, but then he concludes there wasn't any collusion because of his own invented narrow definition. In terms of independence, again, the whole appointment lowered the independence. The intelligence, again, as with HET, is provided by the intelligence unit of the PSNI, which has a large element of staffing by former RUC Special Branch men. Reports are being rewritten to exonerate the police. There are deep divisions, there were deep divisions in the office, with some senior investigators refusing to sign off on reports that were then published because they've been changed to not reflect their actual findings. The Criminal Justice Inspectorate, which is an independent inspectorate body, has found bad governance and so on. And so much so that the current Ombudsman was forced to resign, although he is still formally in post. But recently they've reinterpreted legislation, got apparently a secret counsel's opinion. That means that they will not investigate past cases that had been investigated by the police in the past. So that it's a completely narrow interpretation, not one that Nuala alone adopted, and that is going to restrict its freedom of operation. And we are very concerned that what's happening is that with the appointment of a new ombudsman imminent, well, at least I understand it's down to the last four, Minister David Ford was telling me yesterday, but although he's not involved in the appointment process, it's the office of the First and Deputy First Minister that makes the appointment. But what we're concerned about is that his or her freedom of action is being constrained and hamstrung by a number of developments, in particular this reinterpretation of the legislation. Now, there is a process supposedly of reform going on because the Ombudsman's investigation into historic cases has had to be suspended, and it will really be very important that friends in the United States maintain pressure upon the Ministry of Justice to make sure that this program of reform is effective and restores the police ombudsman to what it once was, a very powerful and highly respected institution which is essential to maintain trust in our new police service.
Mr. Thompson.
Thank you, Mr. Chairman. I think effectively we have three key mechanisms that are dealing with the past currently. We've inquests system with the coroner. We have the historical inquiries team and the police ombudsman. And what we effectively have is we have a number of senior civil servants, formerly the NIO within the Department of Justice and around all of these issues, and former special branch people who themselves are actively being scrutinised by these processes back in the system, and they're thwarting any examination. Let me give you a couple of examples, if I will. I'm supporting a number of families that have been affected by the policy of shoot to kill, which was investigated in the mid-1980s, which took place as 6 killings over the matter of a number of weeks in late 1982. The coroner initially abandoned these inquests. Geraldine's husband, Pat, was our chairperson, got him involved to take the cases initially, and he fought. And the then Chief Constable refused to cooperate with the coroner, Sir Jack Carman, who is now deceased. Those inquests post the European ruling of May 2001 were reopened by the current coroner. There was agreements to provide redacted copies of the report conducted by John Stalker into these killings, and was concluded by Colin Thompson. In court 2 Fridays ago, counsel for the Chief Constable said that there was 172,000 documents constituting 1 million pages, and that he was now not going to hand them over. Now, these inquests had resumed 5 years ago, and there was an expectation that they would now begin. There are 2 police officers appointed in the PSNI's vetting team that are now going to read these 1 million pages before the Chief Constable will decide to hand over the material. These same 2 police officers in the vetting process have to also look at 33 or 34 other inquests with voluminous material. We have a process of thwarting and slowing down and not cooperating. And at the heart of this are people within the special branch, and they are not accountable to the Office of the Police Ombudsman. There is one senior former manager within special branch, and he is employed as a consultant around the legacy unit. This person has been questioned in the past by the Ombudsman in regards to his knowledge about actions that took place with collusion. In 2007, my own details were given out by a member of the PSNI who was a civilian worker, and I followed the case. He gave my details to loyalist paramilitaries who were targeting me. I then spoke to the Ombudsman, and the Ombudsman told me in April 2007 they didn't have jurisdiction. I've raised this continually. There are now almost 300 former officers inside the PSNI. They're involved in training, they're involved in intelligence, and they're involved in legacy work. We aren't going to get to the bottom of this in terms of we continue in this vein. We do need US assistance and support. In one sense, the PSNI are actively politicking on these issues through the HET or through their own mechanisms, and concealing truth, and you know, not dealing with the cases in an effective way.
Just so I'm clear, when you said in your testimony and just referenced that former RUC members, including Special Branch, have been reemployed by the PSNI to work on legacy issues as civilian workers, how does is that 300 number you just said, or is that? It wouldn't.
It wouldn't be all of them. They're through the PSNI in various capacities, but in legacy, this person is employed as a consultant, and he is effectively deciding what happens to the material. So he's in control in many regards.
Yes.
So yes, just to add to that, these civilian staff, so-called, have all been hired through an agency, and there's clearly some kind of, an employment agency. And the difficulty is that they are, the police have now admitted to the policing board that there were 300 and some odd involved, and has detailed where they are working, and some of them in intelligence and training, as Mark has said. But the difficulty is that as civilian staff, they are not actually accountable to the police ombudsman. So, as well as being ex-IUC Special Branch men, whatever they do is not within the jurisdiction of the police ombudsman. We have asked the Deputy Chief Constable actually to answer questions whether these so-called civilian staff are tasking warranted police constables. Are they involved in operations? Are they involved in surveillance? Are they in a back office, or are they on the streets? And we have received no reply.
Who vets them to ensure that they have no baggage?
Well, exactly.
Okay. Ms. Lundy.
I would just like to add to what the previous speakers have said, and I'll just bring it back again to the HET. Yes. And this is not in the public domain, but the foundations on which the HET is built are very shaky, because the HET employed 31 ex-RUC officers, some of them Special Branch, to go out to every police station in Northern Ireland to collect the documents, collate the documents and bring them back to the HET to be stored so that the re-examination of cases could take place. Now, I would ask, this is certainly not independent, and it raises questions about, the documentation that was collected. So this is the basis, the foundation on which the HET is built. And I put it to the Deputy Director of the HET, why have you done this? This will certainly, I would suggest, raise questions and concerns. And he said, well, it would cost too much to employ people from outside Northern Ireland, and actually these are the people that know where the documents are. And
that's a red flag in and of itself.
Yeah.
Would there be any way of knowing if certain documents went missing or were shredded?
Well, you see, you don't know. It's hard to tell.
I have no idea.
And that's the point.
Mr. Thompson.
I can give some insight into that. The PSNI have destroyed documents that were stored at Gough Barracks in relation to interviews of suspects that were detained after murders. And the reason that they give for the destruction of this material was, well, was that it was stored in a store that had an asbestos roof, and then under health and safety, they had to destroy the documents. I was at an inquest in which documents were destroyed, at which the coroner had said that they could have been copied and preserved. Now, that's happened, and we don't know if it's happened with the forensic exhibits also. There's unclarity about that. But even in regard to the historical inquiries team and the role of some of the most controversial things, you do have a report that's been submitted, and it was referred to by Congressman Engel in regards to Sean Graham's bookmakers. The HET looked at that case, and quite controversially, at the heart of that case is a weapon that was used, a 9mm Browning pistol, to which the killer of Geraldine's husband, Pat Finucane, Ken Barrett, stole allegedly from a military barracks. He provided it to William Stobie, who gave it to his special branch handlers. It was handed back and used to murder Aidan Wallace, and then 6 weeks later used in the bookmakers' attack. Lord Stevens found out about the history of this gun and that Special Branch had handled it. When he rumbled them, they told him they deactivated the weapon. But the killing of Aidan Wallace would have made that quite obvious to the Special Branch that it had not been deactivated and was subsequently used in the bookmakers to kill 5 people, along with another weapon supplied by Brian Nelson. The HET examined the case, and they said that the interview notes concerning the 9mm Browning pistol were disposed of. We uncovered those documents at the Public Records Office, and it showed that a man in possession of the gun on his way to carry out a murder was arrested, and that he was the son of a serving police officer. We also found in the discovery of those interview notes that the forensic report of that weapon showed it to be mechanically sound. Now, if the HET are going to say that these are disposed of, and these families met Owen Patterson at the Northern Ireland Bureau event the other morning, and they asked him this question, and he said to them, "It has nothing to do with me. Take it up with your own executive." The British government are no longer there. And one of the relatives said to him, "But British military intelligence, including the people that murdered Pat Finucane, are centrally involved in this incident too." And that Judge Corey touched on this in his report into Pat Finucane's murder. And he then said, "Go and talk to David Ford." Now, other relatives talked to David Ford, and he said, "We can't look at the future, look at the past because we've no money." Brian rightly referred to how these people were recruited. It's been revealed that there was £60 million spent in recruiting these former people through a private recruitment firm. That does not include their salaries. So when we are being told you can't have inquiries and we can't look at the past because of the cost, we then see that there's £500 million on patent. There were £250 million to the UDR in terms of a pension payoff, tax-free. There was £20 million given to the RUC reserve in an ex gratia payment. There's been hundreds of millions of pounds spent in covering up the truth. This is not about cost, it's about will. We can have public inquiries into planning, into health and into everything. It's only when it comes to these issues that we can't. And it's about the British government using their sovereignty as a shield to prevent the truth. We do need international support and international intervention. And the peace process is an example of how all the big issues were handled and addressed with that support. You are allies of the Americans. The Americans are allies of the British, as are the Irish government. Enda Kenny, the Taoiseach, has rightly stood up and said what needs to be done in one of the cases in regard to Geraldine and her family and Pat's murder. What we need to do is bring them over the line. John Finucane and I were in San Francisco during the election campaign prior to the election of Barack Obama as president. And we were able to initiate a process with Irish Americans and other activists to secure his commitment to a truth and reconciliation process pre-election. We need to see it through. The Taoiseach, the American administration and the American president need to bring David Cameron and Owen Patterson over the line. They're on the wrong side of the line. And we need to get them across it. And as allies, you need to support them to get to the place where they need to be, to build a better future for our society and to address the core issues that need to be addressed. And we'd urge you, please, to do that.
Could I just ask you, has there been any indication that President Obama has done that?
As you say, we don't know what was raised. There are no journalists raised the issue that, here we're standing in Washington with the president is a prime minister that has acknowledged not only that there was collusion, but he's powerless to do anything about it. Who runs the country? And I think that's the pertinent question. What we need to do is we need to try and engage the White House, and we need to say, as allies of you, Mr. Cameron, we want to bring you to the place and to the right place. You are on the wrong side of this. We need to get you across the line, and we need the one last push to do that. They need to honour the commitment in terms of that, but wider out there in society, we need to look at the issues that are across our communities, and they are They are surfacing, if not on a daily, on a weekly basis. And we need to address it.
You know, I would just note for the record that we will send a letter to the President and find out what, if anything, he has done. But on human rights globally, President Obama has been a serious disappointment. When Hu Jintao, the president of China, was here, I actually put together a press conference of people who had spent upwards of 20 years in the Chinese Laogai system, including Harry Wu, Rabia Kadir, and many others, Wei Jingsheng, who is another great human rights activist. And here is the man who is the jailer of Liu Xiaobo, the Nobel Peace Prize winner of 2010, and his jailer is at the White House. President Obama obviously got the Nobel Peace Prize and preceded Liu Xiaobo by just 1 year. And we asked that the President raise in a public forum, the press conference or any other way, human rights abuses in general and Liu Xiaobo in particular. When the Associated Press asked President Obama and especially Hu Jintao about human rights, the President ran interference, our President, for the President of China, and it was so egregious that the Washington Post did an editorial, and the headline was, Obama defends who, President Hu Jintao, on rights. And Obama offered an explanation, which I find despicable, where he said, well, they have a different culture in China, and they have a different political system. All these tens of thousands of Chinese human rights activists who are languishing and being tortured daily understand, as does Hu Jintao, what human rights and democracy is all about. They just choose not to have it, and they prefer dictatorship. I have repeatedly raised these issues with Hillary Clinton and others, and there has been muted silence as to what the President has done vis-a-vis China. We will ask by way of letter if this has been asked, and, you know, hope springs eternal. My hope would be that the President, you know, into his 4th year as President, would raise the issue and do so in a serious way with Cameron, Prime Minister Cameron, to try to get specifically a public inquiry for the Finucane case. But all of these, not new, but maybe they're new. Maybe you can, I mean, when did it get worse like this? Maybe you might want to speak to that. When was the definition of collusion changed? You know, we all were operating under, you know, the Peter Corey, and you know, a very, very serious definition of collusion, and you might want to speak to that as well. When was that changed?
It
Yes,
was
Mr.
in
Thompson.
June last year, if I'm not mistaken, on the Loughlin Island report,
Okay.
which you have in front of you with the families, the Loughlin Island massacre. Their report was lodged 5 years ago and published in June of last year, July last year, and it was at that press conference that the families had made public that the week leading into the publication of the report that the Ombudsman had decided not to use the definition set out by Judge Corey and by Lord Stevens. The disclosures in regard to the HET stuff are ongoing, and I could talk all day about them. The disclosure in relation to Sean Graham's bookmakers about the disposal of the material was last year, and it was in October of last year that we managed to obtain from the Public Records Office the interview notes and forensic report of the weapon. So this is ongoing and it's current.
Yes, Mr. Gormally.
Yeah, well, I mean, the point is about the definition of collusion that it's been varied and contradictory, and it isn't that the new Ombudsman has come up with a definitive new definition, but it varies from case to case. But as far as I'm aware, in no case that the current Ombudsman, and correct me if I'm wrong, Mark, in no case that the current Ombudsman has signed off has he actually come up with a finding of collusion.
No, it had been taken a given that they were working to the definition as set out by Stevens and Corey. And what happened in an examination of a bomb in Claudia that was carried out by the IRA, one of the senior people that we refer to of Special Branch who's now working in Legacy as a civilian worker interfered with the office at that time and tried to overturn the findings, and we were being told that they were using the definition of Corrie and Stevens in regard to that report.
Let me just, before concluding, and ask if you have any final comments you'd like to make. Is there any court venue that, Geraldine, Finucane, that you could avail yourself of, including the European Court of Human Rights, to try to compel the British government to finally, at long last, to provide this public inquiry?
Well, after the announcement
Yes.
in October, we had a family discussion with our lawyers, and we have decided to take proceedings in the High Court in Belfast against the British government, asking them to review the decision, to have a review as opposed to the inquiry that was promised. We went to court in January and we were granted leave to proceed to the full hearing. That was granted unopposed, and the hearing is set for the beginning of May. I would presume that no matter what way it goes, it will be appealed, and then it will probably go to the Supreme Court in London. So we are at the start of a judicial process.
As I indicated, I will be introducing a new resolution. I just would note for the record that I've offered four resolutions that put the House on record. And one of them was signed by President Bush, because I did it as part of a larger bill, and that was in September of 2002. The first was in 1999, second in 2002, third in 2006, and the fourth in 2007. All of those were passed. We will do it again, and we will never quit. You know, it's interesting that in cases of civil rights in the United States, when killers of African Americans are found there's no statute of limitations on murder, and that includes collusion or those who were accessory to those crimes, nor should there be here. And so I just want to assure you that this member, and I'm joined, I know, by many others who are deeply concerned as well, will not let up as well. So we will also look at, and I would appreciate your thoughts on this, whether or not it might be timely to invite back to this commission Judge Corrie, to get his insights once again, because he played obviously a crucial role in cobbling together that agreement. So we'll look for your advice on that, and others who might come before the commission to amplify, provide a better, more depth to the record, because again, what you all have provided is just staggering in its disappointing features. So I thank you for it, but I wish you had better news to offer. Is there anything else? If there's any concluding remarks any of you would like to make, we certainly would welcome them. But
my concluding remark is, I think that what needs to happen is an independent, international truth recovery process. I think it is absolutely clear now that the package of measures, aspects of that package, are simply not delivering. They're hugely problematic. So I think the way forward is an independent, international truth recovery process.
thank you. Again, I want to thank you for your testimony, for your insights, and bearing witness to some very horrific truths. Hearing's adjourned.